Thank you very much, Mr. President. It's a great honor and privilege to be here. My remarks will focus on the relationship of early warning and prevention of genocide to early warning and prevention of crimes against humanity, given that crimes against humanity will be the subject of diplomatic negotiations over the next 4 years for the adoption of a new UN convention. Simply put, whenever genocide occurs, it is inevitable that crimes against humanity also occur. A crime against humanity exists whenever there is a widespread or systematic attack against any civilian population taking the form of various types of acts, such as murder, serious bodily injury or mental harm, enforced sterilization, and forcible transfer of population. In short, all of the acts identified in Article 2 of the Convention Against Genocide. While crimes against humanity can occur in a situation where genocide is not occurring, the opposite is not true. Commission of genocide inescapably entails crimes against humanity. Thus, techniques for early warning and prevention of crimes against humanity can equally serve as a method for early warning and prevention of genocide. On December 4th, 2024, the UN General Assembly adopted Resolution 79/122, which launched the process for a diplomatic negotiation of a new UN convention. If successful, those negotiations will lead to the adoption of the UN Convention on Prevention and Punishment of Crimes Against Humanity. The General Assembly's resolution calls for preparatory committee meetings in 2026 and 2027 to be followed by diplomatic negotiations in 2028 and 2029. Thus, if all goes well, the convention will be adopted in 2029 and enter into force at some point thereafter. The central impetus for these negotiations are draft articles finalized in 2019 by the UN International Law Commission, for which I had the privilege to serve as Special Rapporteur. Those draft articles are available on the ILC's website, along with detailed commentary that explains the meaning and legal basis for the draft articles. Several elements of the ILC's draft articles address prevention. Draft Article 3 would obligate states to prevent crimes against humanity, whether or not committed in time of armed conflict. Draft Article 4 is dedicated to that obligation of prevention, requiring states, in conformity with international law, to take effective legislative, administrative, judicial, or other appropriate preventative measures in any territory under the state's jurisdiction. Further, Draft Article 4 would obligate states to cooperate in this regard with other states, with relevant international organizations, and as appropriate with other organizations. Draft Article 5 would obligate states not to return persons to a country where there are substantial grounds for believing that he or she would be in danger of being subjected to crimes against humanity. Though not expressly styled as an early warning mechanism, Draft Article 8 obligates each state to undertake a prompt, thorough, and impartial investigation whenever there is reasonable ground to believe that acts constituting crimes against humanity are being committed in any territory under its jurisdiction. In short, if the start of a genocide likely would consist of crimes against humanity, then detecting such crimes at an early stage through investigation can serve as early warning that a genocide might soon unfold. The ILC's draft articles do not call for the establishment of an institutional mechanism for the new convention. The ILC elected not to make any proposal in that regard, leaving it to governments to address that issue in the course of diplomatic negotiations. One possibility is to create a new treaty committee. Another possibility is to accord certain responsibilities under the convention to existing UN bodies, such as the Office of the High Commissioner for Human Rights, or the Office on Genocide Prevention and the Responsibility to Protect, including the Office of the Special Advisor on the Prevention of Genocide. Presumably, states will wish to be thoughtful and effective in pursuing these mechanisms, and perhaps even be innovative in that regard, yet with an eye to limited resources and the avoidance of duplication. When negotiating over the next few years, the rights and obligations that will be embedded in a UN Convention on the Prevention and Punishment of Crimes Against Humanity, there will be great benefit in drawing upon the lessons learned and best practices developed for the prevention of genocide. Since I will be asked to serve as an expert to the United Nations for those negotiations, I welcome learning more about early warning and prevention of genocide, given the synergies between these two types of atrocity. Adopting a new UN convention would be an important step in furthering international human rights law, as well as international criminal law. But to truly succeed, it should be done with an eye to the strengths and weaknesses of other areas of international law, in particular rules and mechanisms aimed at preventing genocide. Thank you, Mr. President.